Lorcan is my dear friend, and I've so appreciated getting to know you, Lorcan, over the years as we have fought the battles for freedom in the European Court of Human Rights. You are ADF's European Legal Counsel with the responsibility for shepherding cases through the European Court of Human Rights. Not a small task, not an easy task, harder than herding cats for sure. And you're an Irish barrister. You didn't give me much more than that, so I'll ask you to just maybe give us a little bit more, fill us in a little bit more about your bona fides in terms of previous legal practice, if you care to, if you're allowed to. But sure. Please share with us, Lorcan. Thank you for being with us. We're so delighted to have you with us to share your experience and wisdom on this very important topic. Please share. Thank you.
Thank you very much, Mike, and good afternoon or good morning, ladies and gentlemen, depending on where you are. It's a real pleasure to speak to you today in relation to the general issue of homeschooling, but with a slight bias on my part to the international courts and international law. As Mike said, I am an Irishman. I'm a barrister by profession, but I work for ADF International. I'm their legal counsel here in Strasbourg, which is where I'm joining you from. And this is also the seat of the European Court of Human Rights, which for those of us in Europe is obviously a very important venue for determining the extent and the scope and the application of the European Convention on Human Rights. And very often we see our national litigation on a range of issues end up here in Strasbourg for a final determination. And that is true of homeschooling. ADF works in a wide range of areas, essentially based around our Christian understanding of human dignity. The right to life would be primarily among those, the right to religious freedom, and then the rights of the family founded on marriage. And that's a lot of my work revolves around those principal areas. But as Mike said, and as indeed as all the speakers have said, the right to educate one's children in accordance with your beliefs is a core element of the rights of the family as they are protected in international law. So drawing in from the large UN treaties and the Universal Declaration of Human Rights into the European Convention, I want to give you a little idea of where we found ourselves in relation to that, and then to come down to a national level jurisdiction, my own, the Republic of Ireland, to give you a sense of how we've seen some litigation successfully move to the higher courts there. So now I'll try and share my screen with you. So I beg your indulgence. Hopefully smoke doesn't start coming out of my laptop because I have a presentation. Oh, here we go. Right, so this should work. So fingers crossed. Okay, so yes, the first picture, terrifyingly enough, is a picture of the European Court of Human Rights. So this ugly building is the venue of a lot of the dramas in the areas that I work with. And really what I'm looking at here is the convention. And crucially, just to mop up any confusion, it's not the European Court of Justice and it's not the International Court of Justice in The Hague. So we deal primarily with the convention, obviously. And the crucial thing to remember for those of us who are talking from a European perspective is that there is a direct right of application from every individual who is on the territory of a member state. So you don't necessarily have to be a citizen or even domiciled or habitually resident. So that makes it a very important court. How important it is depends on where you are, really. And so this is just a quick look at a 10-year period between 2010 and 2021 of compliance with decisions from the European Court of Human Rights. So the lighter the color, the more compliant the country is. The darker the color, the less compliant. So it's pretty clear there Russia does not really pay very much attention to the decisions of the European Court of Human Rights, whereas in Western Europe, it is important. Now, for our perspective, this is problematic because the European Court of Human Rights has not been helpful on the issue of homeschooling, and that's putting it mildly. But let's look at where the court derives, let's say, the principal statement in the convention scheme for the rights of parents, and that's under Article 2 of Protocol 1. Virtually every country in the convention has signed up to the optional protocols. This is protocol number 1, which came in very early after the full convention was signed in 1950. The Protocol 1 was brought in the mid 1950s. And very clearly there, it protects the right, we would say, of parents to, or it articulates the right and protects it in law of parents to protect or to direct the education of their children in conformity with their own religious and philosophical convictions. And we have really stressed this right in any litigation that we've found ourselves taking at the level of the court in Strasbourg. And I think Mike would agree with me, that is a very strong statement there in Article 2 of the right to parental control of education. Sadly, though, and we all know this, there's often a disconnect between what the law says and what courts will interpret the law as meaning in practice. So just to give you two principal examples that are cited by the case or by the court in all decisions in relation to homeschooling, they're relatively recent. They're certainly from the last 2 decades, and they both involve Germany. And Conrad in Germany and Dogen and others in Germany are the two that I've cited there. And they are very weak jurisprudence on education. Essentially, and they directly relate to homeschooling as opposed to other questions such as sex education and so on, that the country, that is Germany, has a right, as it were, or has certainly the margin of appreciation, as the court calls it, to be able to restrict education provided in the home on the basis that education, as the court sees it, is a collective activity, that it's not simply about imparting information, but it's about forming citizenship. And the court was very keen to stress that Germany has a legitimate interest, that is, that the state and the authorities, in restricting the emergence of parallel societies. So that's a very troubling, I think, set of decisions, principally around Germany, that have come from the European Court of Human Rights. And I think it's fair to say that in terms of how these cases have developed, the court has cited those two admissibility decisions in every subsequent case that we've taken to the court. And so I think really when we look at taking the case as far as the European Court of Human Rights, and this can be true, sadly, of international courts generally, once they have taken a damaging position like this, it can take decades really for them to overturn or move their jurisprudence. And I don't see any immediate evidence that they're going to change their position in Strasbourg. In practice, then, this means that there are real victims associated with this kind of approach. And this family is the Wunderlich family, a lovely German family who were residing in the state of Baden-Württemberg across the Rhine from me here. And they have been the subject, or the victims rather, of some pretty extraordinary levels of oppression and persecution by the German educational authorities for their decision to homeschool their 4 children. And you can see them there. We, together with Mike, have been involved in an HSLDA in this case for quite a number of years. And it eventually made its way through the German domestic courts, where the family, as I say, were in and out of court. On one occasion, the German police surrounded their house for a dawn raid and took the children into immediate care with over 50 policemen and officials present. So the kind of overreaction that the German authorities had to this family homeschooling is indicative of the approach Germany takes to try and force parents to send their children to schools that are recognized by the state. This case did, as I say, went to the European Court of Human Rights. The court communicated the case. In other words, it accepted it. Alas, the court applied its previous set of decisions involving Germany and decided that the case was inadmissible under Article 2, Protocol 1, and also under the claims we made in relation to interference with private and family life under Article 8. So the message was sent out by the European Court of Human Rights that it was okay for the German government to essentially take children into care where there was no evidence whatsoever of any harm. The children weren't subjected to any harm. They were clearly competent in relation to any testing that was done academically, and the parents were committed to their education, but that still did not sway the court in Strasbourg. And that's really, I think, a major problem when it comes to the international courts in Europe, at least, that we have this very difficult and troubling jurisprudence already in place. Moving on to some good news, though, this is the Burke family. And over in the middle there, you see a young Elijah Burke, who's now in university. But at the beginning of the pandemic in 2020, the Irish government decided that that children would not sit state exams at the conclusion of their second level education, but that their grades would be assessed by their teachers. And this posed a problem for homeschooling families because the Irish Department of Education decided that parents who were homeschooling could not assess the grades of the children impartially for the purposes of a university application. And so therefore, they weren't prepared to recognize homeschoolers' right to matriculate to university. Now, young Mr. Burke here and his family took a case after a long process of trying to convince the Irish authorities to make some other mechanism available for homeschoolers so that they would have their grades assessed maybe by way of a correspondence exam or some other form of assessment. The Irish Department of Education refused completely and simply put no form of assistance or redress in place for them. They appealed that decision, or they took a judicial review to the High Court in Dublin. They won that case. Then I think in a decision that one can only kind of be completely baffled at, the Irish Minister for Education appealed her loss to the Court of Appeal. And at the Court of Appeal, 3 judges ruled that not only was the Department of Education and the Minister for Education in the wrong for not facilitating the homeschooling family, but they went far further and they decided that homeschooling had an enormously central part to play in the expression of parental rights within the Irish Constitution. And it was remarkable to see 3 judges who, all 3 of them really, I think it would be fair to describe them as liberals, giving a decision that was rooted in natural law theory about the importance of the family unit and the fact that children's rights can only be recognized within the family unit. And so the decision obviously was to do with homeschooling, but has had, I think, much wider application in terms of strengthening parental rights generally in the Republic of Ireland. So that's the reason I show you that case is to counterpoint it with sometimes we find that international courts do not give us the decisions we want, but then domestic courts can give very good decisions. And in that case, a lot of international law sources were used by the family in their domestic challenge. So they took the law, such as mentioned earlier by Mike Ferris and Mike Donnelly, that exists at the United Nations level, and that also exists at the level of the European Convention on Human Rights. They applied it directly in their domestic proceedings, and they got a very good outcome, an outcome that they would not have gotten if they had to appeal to the European Court of Human Rights. So what are the takeaway points then in terms of taking cases internationally? And this building that I have in the background of the slide is the European Court of Justice, which is a European Union court. I think it will become a more important court on this issue in the future as well, considering the Charter of Fundamental Rights of the European Union. But international law is good, but the courts are weak, is the first point I would make. So insofar as you can, use international law arguments in your domestic cases. The points that you can draw out from the UDHR, from the ICCPR, and from the Covenant on Economics and Social Rights are strong, as are the points that can be made and argued from the European Convention on Human Rights. And deploy those effectively domestically, because I think they're much stronger, or they're probably much more useful at the domestic level than they are at the international level. The next point is really, I think, would say the more unreasonable the government's actions, the better the case. And in the case of Burke and the Minister for Justice, we had very unreasonable actions by the government in applying what was really a totally ridiculous approach to that family, and refusing to offer them any kind of mechanism or workaround to have their grades assessed for the purpose of applying to university. I think Lizzie will be talking about the actions of the government in the UK case that happened recently. And in that case, you could counterpoint quite strongly, I think, that the judge took the view that the local authority there was behaving reasonably within its statutory powers. So where the government is overreaching very strongly, those are the cases very much to take, and they set very good precedents. And as I say, use comparative international law. That's not just international law from treaties and covenants, but also case law from countries where homeschooling is strong. The United States, a good example, the Republic of Ireland, obviously I mentioned a case there recently, and where we can find other decisions then from your own jurisdictions or from neighboring jurisdictions. Use those effectively, deploy them effectively as well. And that's why I think the work that HSLDA and this Global Homeschooling Exchange forum is doing is so important, because they have, and I'm going to stop sharing at this point, they have at their fingertips really some brilliant resources internationally that can be used even where you don't have a domestic lawyer that has a lot of experience in this area. And I see a number of the questions that have been raised so far in the Q&A box make that very point, which is that it's not a speciality that you will find usually, particularly in smaller jurisdictions where there's no history of homeschooling. And the point I would make there is, if you have a competent lawyer, we can provide resources that go right across the world, from the United States to European jurisdictions to Asian jurisdictions, and good examples from international law that will really strengthen the application that you make domestically, and show that this is not just a strange and narrow form of education, that it's quite common around the world and that it's growing.